So, welcome back. And as I said, it's my great privilege to be introducing our first keynote for this afternoon, Victoria Owen. Victoria holds the position of Information Policy Scholar Practitioner in the Faculty of Information at the University of Toronto. Her background is in the library administration at the University of Toronto and in special and public libraries, including the CNIB Library of the Blind. Victoria holds a Master's in Library Science and a Master's in Law, specialising in intellectual property. Her research focus is in information policy with a focus on copyright, preservation and the public interest. She is the chair of the Canadian Federation of Library Associations Copyright Committee, a board member of the World Intellectual Property Organisation's Accessible Book Consortium, and a member of IFLA, the International Federation of Library Associations and Institutions FAIF Committee, the Freedom of Access to Information and Freedom of Expression. She's also a member of OLA's Copyright Users Groups and a past chair of IFLA's Copyright and Other Legal Matters Committee. And I also had the privilege to serve with Victoria on the IFLA Governing Board for 2017-2019. So I'd really like to extend a really warm welcome to our first keynote for this afternoon, Victoria Owen. So welcome, Victoria, and you're joining us from Toronto, where I think it's probably nearly 11 o'clock at night. So thank you and welcome to this afternoon's session.
Thank you very much, Vicki, and it's a great pleasure to be here, and thanks for the invitation to participate in your conference. Today, I'd like to talk to you about the battle for digital rights and copyright and stemming the tide of incursion into the public interest. So libraries and information professionals operate in the dynamic environment with copyright and digital technologies. And the central mission of libraries, archives, and museums. So I intend to use libraries, archives, and museums throughout, but mostly I'm just going to say libraries, but please read it as libraries, archives, and museums. And our central mission is to provide access and to preserve information and knowledge. So in the digital environment, that mission is under threat because we're hampered by the application of copyright law in the digital environment, and we're intimidated by the ambiguity in the law that should be guiding our operations. So today I'd like to examine with you the copyright framework in which we operate and how to understand it better, how we can understand the user's rights perspective, and how to develop a strategy to engage in the battle for digital rights. So we are well aware that libraries deal with copyright as an integral part of our operations. The acquisitions, use, and preservation of works puts information professionals squarely in copyright's frame. So we negotiate access, we prevent overreach, we pay for the uses, and we prevent the waiving of statutory, we try to anyway when we can, prevent the waiving of statutory rights of access and use when we are negotiating the terms of agreements. And as a result of our experience in dealing with copyright in our daily practice, there's widespread awareness among information professionals of the many rights of copyright. And I think we're mostly aware of the rights holder rights in copyright more than we are in our own home territory of user rights. I think from my conversations with information professionals, it is true that we're very, very hyper aware of the rights holder rights. So in the copyright regime, the purpose of users' rights, including all the exceptions and limitations for libraries, archives, and museums, is to ensure the essential balance in the rights scheme to safeguard the public interest and to protect against the diminishment of its function from being subverted and subsumed by private interests. And we're going to see some examples of that in our conversation today. Libraries are society's safe havens where access to information and cultural preservation are facilitated and safeguarded. And we're recognized worldwide as distinctive guardians of the public trust, specifically designated by statute, and often by statute, and as institutions that are necessary for the state's discharging of its responsibility in serving the public interest. Libraries around the world represent the most accessible and dependable sources of information scientific materials and knowledge. And this is very significant in all of our worlds, but it is most significant in the developing worlds. And supporting this, part of the values that we operate with are the values of our profession. And those include intellectual freedom, privacy, literacy, rationalism, stewardship, which is unique to us for the preservation of our documentary heritage, equity of access, democracy, and service. So libraries and archives and museums are the places where the public and the proprietary meet. And we deal in information. And information is a constitutive force in society. And the way it is treated as a commodity or as a resource has profound implications for us and how information is used and how it's viewed in society. And we'll see that throughout this conversation, that part of it, the part as a resource, when it is part of our users' rights framework, or when it's part as a commodity that is for sale. In the analog world, libraries are the repositories of the world's knowledge and own their own holdings and collect and maintain access to the content without restriction and without oversight. And that our unique functions and guarantees of libraries are threatened in the digital environment, because in that environment, access and all uses of works can be tracked and invade our privacy rights and impinge on our intellectual freedom through surveillance, because we know that when we're surveilled, we search differently. And the expansion of rights in the digital realm, such as the protection of digital locks, that often overreach the fair dealing exceptions or users' rights. So we'll look at the Google Books case as an example with the overreach. And we need to remember that all uses that are not enumerated are in the public domain. And works that are in the public domain are not protected. The public owns them and anyone can use them. So we are experiencing an encroachment on the public domain as more and more uses of works become enclosed or restricted. And this is particularly prevalent as we contemplate the protection of works created by artificial intelligence. This week, the Google executive director said AI is like fire and electricity. It's so elemental, and it is going to transform the world. So I think the battle for digital rights in AI applications is underway, and there is territory to gain or to lose in there as more and more becomes enclosed. So our framework is the National Copyright Law, and in the public interest, copyright is our public policy space. So it's our home territory, and we have every right to operate in it and advocate in this environment. And I just wanted to have a little aside to say the statements that I'm talking about now, what we're going to talk about in the copyright law is about the common law and not customary law. So Canada and Australia both have Indigenous peoples in the land we share, and the customary laws do not operate in the same way as common law. And we're going to look at the differences in a few minutes. But what I'm going to talk about right now is copyright law. And it is national in context, and everything that applies to our copyright laws is in the Act. So if it isn't in the Act, if that right isn't enumerated in the Act, it doesn't exist, and it is in the public domain. And copyright's balance is in the Act, in both Acts. The public interest goal is articulated as reasonable access to works for the benefit of society, and the private interest goal is there for rewarding creators. So there are three sets of rights in copyright. The economic rights, which are the most prominent set of rights, and they are, we all know them, to produce, reproduce, translate, perform, publish, communicate, and quite a few others. And the moral rights are less prominent, but they're there and we're aware of them. Typically, they pertain to attribution, but the integrity of the work of the author and the association of the work. And there are remedies if a reputation is impugned. So users' rights are the least prominent of all the rights. And this is where permission to use the work is not required. This covers facts and information, unsubstantial taking. So when you just take a little bit, fair dealing exceptions for research, private study, education, parody, satire, and all the exceptions for libraries, archives, and museums, and for educational institutions. So users' rights is where we're going to focus today. They're less well understood, and they pertain to the uses where no permission and no authorization is required. Users' rights are entitlements to the products of authors and activities that by law are not infringements and so are beyond the owner's control. And that's important for us to keep in mind. So there's a relationship among the three sets of rights, and the great majority of the rights belong to the creator or the rights holder, but they are limited by user rights. And the economic and moral rights that copyright protect are those private interests. And the public interest in copyright is vested in the user rights. And as Professor Weber says, users' rights users have rights to do what owners have no right to stop them from doing. And users' rights begin where owners' rights stop. Well, that is true up to a point, because along the margins of those rights exists a legal gray area where the ambiguities in the law are worked out through the courts when we present fact sets that are context specific. And those legal gray areas allow us to experiment and to use the nuances in the law to create public policy objectives. And so one of those examples that I think Canada and Australia and many other countries are dealing with now is controlled digital lending. And in a controlled digital lending context, this happened in Canada during COVID, which we're still in, but libraries are beginning to open. So when libraries were closed, we had all of our content that was unavailable to be used. So the print content was scanned and we created digital copies of it and loaned them. So we loaned them on the same ratio that we held them in the physical format. So if we had one copy, we would lend one copy. If we had two, we could lend two. But that is a context-specific fact set that is around the margins of our rights. So we're just testing those gray areas, that legal gray area that is around users' rights, that cushions us between rights holder rights and user rights. And that's our territory. That's where we belong. It's our policy space. And we need to inhabit that orange slice, and we need to expand it in terms of user rights in these context-specific cases. So when we talk about balance in copyright, we need to understand that balance is elusive and it's pliable. And it's not an equilibrium of opposites. So when we look at this diagram where we have this sea of blue and a little slice of orange, it isn't a balance. And then it isn't static either, because those gray shoulder areas are going to be moving. And they're going to begin to continuously adjust as we bring more social and cultural and economic and legal inputs into the question. So when we look at controlled digital lending, we can see that the social context of it was in a pandemic, in this current pandemic that we're having. So it gave us latitude to experiment and to try something out. And we can look at various court cases when we look at technical neutrality. And if you're looking at technological neutrality, controlled digital lending is a perfect example of that. So that's how we're going to be achieving balance. And that's what we need to work towards. Users' rights are regarded as an important tool to balance the protection and access sensitively so we can further the public interest in making culture widely available. So libraries are also implicated in the international treaty and trade environments. And here we're talking about the commodification of information and its economic impact. And that also puts us squarely in the frame with trade agreements and the World Intellectual Property Organization's treaties. And the WIPO treaties, WIPO is a UN organization, they have in their mandate the need to maintain a balance between the rights of authors and the larger public interest. So that international framework shapes our national legislation. And it also, copyright interests also appear in other international documents that frame our environment. And that's the Universal Declaration of Human Rights, the International Convention on Economic, Social, and Cultural Rights. And since 1994, the World Trade Organization incorporated the WIPO Convention, the Berne Convention, provisions into the Agreement on Trade-related Aspects of Intellectual Property. So that's trade-related, that's commodification of information. So users' rights are recognized in the home legislation of many countries, and yet they remain conspicuously absent in international treaties and trade agreements, in contrast to rights holder rights. So the one exception is the recent adoption of the Marrakesh Treaty to facilitate access to published works for people who are blind, print disabled, or otherwise visually impaired or otherwise print disabled. And the Marrakesh Treaty is a momentous international agreement, and significantly, it's a users' rights agreement. But it remains the only international agreement that deals with user rights and the harmonization of limitations and exceptions. So it offers a counterpoint to that continuous push for international harmonization and the expansion of rights holder rights. So what's happening here, this is the area where we're going to notice the battle for AI is underway, because it is shaping up. It's in discussion at WIPO. AI has no human author, and it is a computational output. So it doesn't exactly fit in copyright. So how will it be made to fit? And is there going to be a separate regime? So we have to remember that the more we enclose, so as AI takes shape and begins to enclose more of the territory, it is enclosing what is now in the public domain. So we need to be aware and concerned about that further enclosure of user rights. So with the exception of the Marrakesh Treaty, the copyright system, well, that's the exception. And then it has been in a continuous process of expanding and ratcheting up. And there is now the rush to claim new territory in the digital realm. So the new territory is taking shape in AI, but it's also taking shape in the user rights realm. And that is, for us, it's very worrying. So it is being noticed that the absence of mandatory limitation and exceptions in society's cultural institutions is becoming increasingly an impediment to access to knowledge. And that, as I mentioned earlier, is happening significantly in the developing world. And this imbalance leaves us in the users' rights area with inadequate rights. And also a challenge that's presented to us is that users' rights remain largely unwritten. So we want certainty, and there isn't certainty because we have to provide the fact sets, we have to provide the court cases, and we have to shape copyright policy and law. So they are largely unwritten. And the language of the statutes can be purposefully ambiguous. And that's always a challenge for us. But when we look at it through the lens of why it is ambiguous, I think it gives us hope that we can influence policy in a more effective way. Because the ambiguity indicates indeterminacy, because there is no end to it. The ambiguity is resolved through context. So if we look again at the controlled digital lending, there was ambiguity. Can we do this? Well, you're presented with COVID and you don't have many options. And so you do it, and it will be resolved through that context. And then it can be expanded from there, because it will prove, I'm sounding so certain, but it's likely that it will prove that that there is a technological neutrality to that information, and that it can be transferred into another format. So the ambiguity and indeterminacy are valuable tools for us. We can claim them and assert rights for users. So I know that in our environments, for ourselves and for our administrators, that the prospect of court action is intimidating. But we have to keep in mind that this is the only venue that will determine the rights of users. So ambiguity and indeterminacy, you may not want to hear it, but there are friends and there are tools. There are tools to help shape the user's rights environment. So when we consider economic rights, the copyright statutes seem designed by big business for big business. And public interest players like libraries, archives, and museums are advocates for the public interest, but we are cast as passive viewers to be affected, but in ourselves not to affect anything. So into this space can leap big business. And I think we've had some indication that this is happening. What once used to be used as a balance for proprietary interests, so that the user's rights were to balance the rights holder rights, are now, so the user's rights are now attracting proprietary claims in the data and information markets. And fair use and fair dealing are also being subsumed by private interests. So tech companies are pushing for the propertization of information. And when a resource is valuable and non-substitutable, the likelier it is to attract that kind of proprietary claim. And this will take us back to the conversation that we've been having at the beginning and throughout of information as a commodity or as a resource. And as a commodity, it changes the characteristic of information for libraries and archives and museums, and it changes the balance by bestowing a market power on tech companies. So big data, big tech, like CCIA, which is the Computer and Communications Industry Association, claims now to represent the interests of copyright exception industries. Now we're talking, this must be a commodity and not a resource, and they are now defined as interests of the copyright exception industries, defined globally as interests, as industries that rely on exceptions to copyright law. But that's our policy space. So the fair use, the Google fair use narrative that they use with the Google Books project exaggerates its representativeness, and they claim to represent libraries and educational institutions. And it may have had some positive effect, but it is a change in the way fair use and exceptions are viewed. And there's a transfer of power to the fair use industry. And we have to consider where that power came from. So we are awash in mass copying technologies, and digitization was one that is one that's very important to us. We know that new intellectual property is predicated on the foundation of the old. And we have the collections, we have the fuel we have the collections that fuel this into new intellectual property. And those are the holdings that are entrusted to libraries, archives, and museums. That's the corpus of works. That's our corpus. But Google partnered with libraries in this project, in the Google's Books project, and they digitized over 20 million books, about 20% of them that were still in copyright. And of course they were sued. That's the gray area, that shoulder area. But the courts found that it was fair use. Now they acknowledged that it was on its face a case for infringement, but because they had a transformative use for the digital files, it was regarded as it wasn't regarded as an infringement. So the courts found that it was fair use, and it was a shallow, in my view, it was a shallow analysis of the public benefit. So the library gives Google access to its books. It gets a digital copy in return, but its use is controlled by Google. So Google retained the freedom to make all the possible uses of the digital copies. And it gave no permission for libraries to carry out, or others under of their users or their researchers, to use the collection, that corpus, whose corpus, to involve automated and systematic use of that collection. So, and each library had its own copy that they could use for their own exclusive use, for preservation, or for access to print disabled people, but no one but Google had the automated access. And so this is where Google now has the exclusive use of the corpus to perform searches and over the computational potential of the whole corpus. So nobody else can make use of it the way Google can make use of it. So this is, through commodification, fair use benefits. What no one owned before is now owned by Google. So the small carve out that libraries were able to negotiate in this was for the use of these digitized copies for their own purpose and for preservation and access to print disabled people. So, but very, very limited use of the digital copy, which has huge potential for use. So this is an example of the overtaking of the public interest provisions by a tech company and the creation of substantive market power. And this requires our notice. We need to do further study, we need to do policy analysis, and we need to have legislative intervention. So I wanted to talk to you a little bit about Indigenous knowledge. And my experience in understanding Indigenous knowledge rights came as I am still chair of the Canadian Federation of Library Associations Copyright Committee. And the Library and Archives Canada hosted an event for the GLAM sector, so galleries, libraries, archives, and museums. And I was introduced to Indigenous leaders and elders and invited into a conversation on Indigenous knowledge and the framework for recognition and respect for Indigenous knowledge in Canada. So I was very keen to address this issue. And I had spent some time thinking about it and looking at the copyright law. I took out the copyright law and tried to imagine how and where Indigenous knowledge would fit. But I really couldn't see it. And the next day, the Ontario Library Association had a conference, its annual conference, and they had a keynote speaker called Jesse Wente, who was an Indigenous journalist. And he spoke on the Truth and Reconciliation report that Canada had done. So in 2015, Canada had completed its Truth and Reconciliation report about the Indigenous reality in Canada. And what he said really impressed me. He said that reconciliation was on us. And it made my head hurt. It really gave me a massive headache, because it was the pain really of changing your mind, of seeing that another way has to exist. I couldn't see it in the common law, but you begin to see it that we need a parallel system. And it isn't really a parallel system, it's another system, because the systems have to connect and interweave. But there is really a need for another system that recognizes the characteristics of Indigenous knowledge that are markedly different from the way common law protects, works in our framework. So in retrospect, I felt quite regretful about the conversation I had on the previous day with the chief and his colleagues. And really, I long to do a do-over sometime, and I hope I can. But we need to situate ourselves in the framework for Indigenous knowledge. And the United Nations Declaration on the Rights of Indigenous Peoples is a good place to start. I understand that Australia has adopted it and Canada is about to adopt it. WIPO's Intergovernmental Committee is working on intellectual property and genetic resources, traditional knowledge and folklore. So it's happening at the international level. Canada's Truth and Reconciliation Report has a number of recommendations on dealing with intellectual property. And Canada's statutory review of the Copyright Act, CFLA, spoke before Parliament, and we advocated for respect and recognition of Indigenous knowledge. And we participate with Indigenous groups in the development of national and international IP. So we need to keep in mind when we think about Indigenous knowledge that it's the non-Western origins of it, that it's local and has a global context, and that Indigenous laws regulate Indigenous knowledges. And in the conflict of laws, so there's a way that in the legal framework that when there is a conflict of laws, there are international principles on how to resolve that. And when we look at our common law tradition, the colonial legal terms are often at odds with the customary laws of the Indigenous communities. And our vocabulary, when we look at knowledge versus property, traditional and living knowledges, collective ownership versus a specific creator, fixation and no fixation, no term limitation versus a term of protection, and that some forms of knowledge are very strictly regulated among a certain group or are considered sacred and then further restricted. And in my understanding from some Indigenous communities, that the concept of preservation is to use the knowledge. And the Western concept of preservation is to set it aside and to safeguard it. So there are some differences. And the other one is the rights are within the owner's control. And when we talked about copyright earlier, we talked about what was within the owner's control and then what was out. And the author has a lot of control. So the owners have a lot of control with Indigenous knowledges. So there is a multiplicity of rights scheme that exists for Indigenous knowledge that I think that we need to be aware of and to take into consideration when we have these conversations about copyright. So respectful approaches to Indigenous knowledge are creating the protocol agreement. And I know Australia is very active and is a leader in this area. So there are a number of principles and recognitions on how to achieve that kind of protocol agreement and agreement on governing principles and how to develop it, informed prior consent, And overall, I think you work with each individual community on the rights and the access that you are contemplating. And overall, I think that we need to support Indigenous peoples in their battle for IP rights to their knowledges. So this brings me to the end of my chat with you, and I wanted to leave you with three things. I wanted to talk to you and ask you to really fully occupy the user's rights policy space. That ambiguity and indeterminacy are your friends and your tools, and we have to become comfortable with using them. We need to remember that if the right is not stated in the law, it doesn't exist. I've worked with a lot of rights holders for many, many years, and there is a lot of overreach, and there's a lot of assumption that if this is in it, then that must be in it. And it isn't true. It isn't. We have to test the waters there. So there is no prohibition on any undefined or any unenclosed use. And that users' rights are elusive and pliable. So that works for us too. That isn't only for the rights holder. Those are our rights, and they're elusive and pliable. And there's ambiguity, and we can provide the context about how we can expand and defend the public interest in copyright. So the second ask is really to actively seek, I know the library administrators are going to cringe, to present library use case fact sets in front of the courts, because the information policy statute in both of our countries is skeletal for a reason. We want more clarity, but we say we want it, but I say we don't want it, because they're skeletal for a reason, because the courts can make a decision on the specific fact set presented before it. And if we have consistent actions by librarians and information professionals, we can shape and influence our customs and practices and influence the courts. So that can be a very powerful action by us to present really good fact sets to the court, and think it through and talk widely among our peers in other jurisdictions, because they will look for precedents in other jurisdictions. And we need not to be afraid to take things to the courts. They're the final arbiter of the public interest in copyright, and we need to use them. And then the final ask is to advocate for the respect and recognition of Indigenous knowledge rights in the legislative framework, parallel to the common law rights, and in conjunction with Indigenous knowledges. Parallel, but not always parallel, so to interweave. So that takes me to the end, and thank you very much for your attention.
Thank you very much, Victoria. And as someone who's spoken on a virtual conference, I understand how difficult it is just to be speaking to your PC without the benefit of an audience. So thank you very much for your presentation. And today, I mean, it's interesting because copyright is such a complex area, and I've sort of noted some of the adjectives that you've used throughout your talk, hampered, ambiguity, elusive, battles and self-havens and things like that. So I guess it is complex, but you've also given us some strong call to actions as well. So thank you. Now I have got a few questions, so we've got about 7 to 8 minutes left. So I might use that time to ask you the questions that have come through, if that's okay. The first question I've got here is there a danger that libraries are naive when it comes to dealing with the tech companies, and that we sacrifice long-term good for short-term gains in terms of access to content?
Well, I don't want to be too harsh. We have made some mistakes. I think we may have lost some of the battles. I don't think we've lost the war yet, well, not yet, but I don't think we will. Because I think we can now, we're becoming aware. I think laterally, when I think of how libraries and information professionals have really stepped up to in their knowledge of copyright in our environment. And, you know, the number of librarians that are dually qualified, it really does speak to people we really, you know, that we have understood the environment that we're in. It's changing, it's different, and we are skilling up to be able to address it. Yes, some things have passed us by, but maybe they won't pass us by the second time. I think this whole subversion of the public interest of our fair dealing rights, and to have the tech companies take those over, I think we really have to talk to our legislators about this. You know, I know Australia has been leading in one of the battles with Google, but there are many battles to be had with Google. And, you know, the other thing is Google does support us in many, I know they come to Canada, I'm sure they go to Australia when you have our copyright reviews, that they are on the side of users' rights. Well, they're on the side of users' rights because they want to leverage them. They want to make more billions. So I think I wouldn't want to call us naive. I would think we're learning from our experiences.
Yeah.
And we're much more familiar in this territory now.
Yeah, and I think, as you say, you know, a lot of people are dedicated to really working on behalf of libraries and users in this space, and people, you know, like you, representing libraries at forums like WIPO, the UN, and really profiling and raising the flag for libraries and creating that awareness as well. So, which is significant as well. I think, you know, we're certainly all very focused on COVID and the impact of COVID, and, you know, we've had some long-term benefits come from COVID. And I've had a couple of questions that are responded to your commentary around the controlled digital lending that was used in Canada. It was unable to be used in Australia due to our fair exception-based legislation and that sort of thing. But so the question I've got is that controlled digital lending is not something we can do in Australia, but it sounds as though it has something that will become embedded for Canadian libraries. Is this the case? And were there alternatives to controlled digital lending which could have been introduced in its place to achieve the same ends?
I don't know what those are, because, you know, a lot of very smart librarians were trying to solve this problem of access during COVID. Yeah. So the first part of the question, can you tell me that one again, Vicki, please?
It just says, CDL is something that we couldn't do in Australia, but it does sound that it's going to become embedded in Canadian libraries. Is that the case? Was the first question.
So, yeah, so that first question, I don't know if it's embedded. I think there probably is a test case coming, but a number of libraries are doing it, and I don't know, cautious about it, but they are doing it. I know a number of libraries have done it during COVID.
Another question, because I've got a few here, so I'll just go through a couple of them here. Copyright legislation in Australia has failed to keep pace with digital technologies. Is this your experience worldwide, or are there countries where technology neutral legislation has been achieved?
Well, I think that there are some countries where they've had, and even in Canada, so the jurisprudence in Canada has said that there's a technological neutrality. So that's there. I don't think it's enshrined in the legislation, because in the last update of our Copyright Act in 2012, the digital locks provision came in. So it wasn't clear that those digital locks don't apply or do apply to fair dealing in the digital realm. So a lot of people are stymied by that, that it doesn't, but it just has to be a test case, and you just take it through the courts. That we can only say that, of course, the technological neutrality would apply. I mean, it is fundamental to the Copyright Act that you have balance, that you have user rights, and those fair dealing rights have got some very, very good jurisprudence precedents behind them. So there are places in the world that are clearer. I can't think of an example right now, but there are some that there's no, you can't override, you can't override statutory rights in any environment, so digital or analog.
Yeah, okay. Is there a danger in codifying user rights that we might end up narrowing them even more than the current ambiguity, especially as context changes and new technologies come online that may not have been contemplated when legislation was drafted? So I guess that's part of the thing, that things are changing all the time as well, aren't they?
Yeah, and the codification is only on that fact set. So it may limit it, it may go against us and limit it for that fact set. But those legal gray areas exist. And the jurisprudence, the history of that, those challenges to fair dealing in Canada haven't gone well for the content industry. They have gone in favor of a liberal reading of users' rights. And I think we need to look at in the international sphere too. So there, IFLA and a number of organizations are working on a draft treaty for limitations and exceptions for libraries, archives, and museums as we speak. And it's been on the agenda at WIPO for over 10 years. So those treaties, they take a long, long time. I worked on early in the 1990s, I drafted stuff that was preparatory to Marrakesh. So Marrakesh only happened in 2013. So it's a long game, and you just get in there and work and pass the baton on. But I don't think the codification is only for a fact set. Fair dealing, that's why they're open-ended, is because you can't determine all of the facts that are going to come before you and all the applications that are going to need to be determined. And we use our best possible judgment. And then, and thoughtfully, if you ask others in the environment what it looks like, then you take that through the courts. And you need people with fire in their belly. We need to be administrators with fire in our belly, because you have to believe that those tech companies, they were testing the waters.
And I think I think what you're saying is the grey areas actually give us the room to advocate and to move and to put cases forward, is really what you're saying as well, isn't it?
Yeah, and then when we're doing legislative reviews, then we go and claim that territory. If it's not already enclosed, then we say that has to remain open. It's really important for that to remain open. AI is going to be a battle royal for that. Like, if there's no author, and so many countries have said, they've defined what authorship is, it's a human authorship. So where we're going to go with that is going to be very, very challenging.
So can you tell us a little bit more about, you mentioned, I think, during your talk that AI is certainly being featured now in the discussions in WIPO that you're involved in. Are you able to tell us any more about that?
Well, they're a special hearing, so that I think there's one coming up in September too, that people can register for and just go and listen. And you listen to the member states and you listen to the NGOs present what they think should happen in the AI environment. So the Canadian Federation, so the Copyright Committee that I chair, we have a working group on AI. And it's a huge challenge because there's so much unknown about it. There's so much that is being charted. And then where that's going is difficult to know. But when you understand how transformative it is, we really need to look at it. So you look at, it's a big topic, but if you look at it in terms of how it's going to affect libraries, how it's going to affect the production of works. So if AI can produce works based on the corpus that we don't have anymore, and get some fabulous, so how do we manage all of that new material? How is it situated vis-a-vis human authors? What happens to human authors? There are many, many questions about that, and how is it protected? Because it's a computational output. That can be That's fact and information, really.
Well, I
So
think you're
let's-
right. Yeah. It's a big topic, Victoria. You've certainly, you've got that right. And I think, you know, you've outlined a whole heap of approaches for us today, but also given us some call to action. So thank you for that. And you know, I think, again, would like to acknowledge on behalf of all the Australians watching, to thank you for all the work that you've done, particularly in the Marrakesh Treaty. You indicated that was a significant milestone for us as a sector and for the world, and thank you for the work that you personally contributed to that, and the work that you continue to do and contribute to the discussions at WIPO. I'm very conscious that it's been a late evening for you. I thank you for joining us and presenting our first keynote today. We're going to take a short break now, and we'll come back in 2 minutes, and Roxanne Missingham will be facilitating our panel session on digital rights, challenging our traditional concepts of access and control. But thank you again, Victoria. It's been fantastic to see you. Haven't seen you, your face for a couple of years, so thank you for joining us today. And hopefully you may be able to stay around for a little while to watch the panel session. But thank you very much.
Thank you. A pleasure.
Thank you.